Now we have our first of three headliners. Marcia Waters, Director, Division of Real Estate, DORA. I think you all know who she is. If you would just put that on right there. And remember to repeat the question. Thanks.
Well, thanks. I'm going to give you guys an update today of what we've got going on with the Commission. And I'll also touch on Community Association Manager licensing, because I know there are quite a few brokers that do that as well as the real estate brokerage activities. So last Friday, you should have gotten an email alert about a new position statement, CB44, which deals with coming soon signs. I will tell you, we haven't seen consumer complaints about the coming soon issue, but I probably on a monthly basis get at least one inquiry from a local board or from a broker about coming soon issues. The Real Estate Commission basically decided that they really wanted to have a position statement to address the issue. I will tell you, from the regulator that's there every day, it was just kind of a no-brainer of look at your brokerage relationship duties and make sure you're following them and you're not putting your commission above your client's needs. But we did do a commission position statement, and basically it just kind of reaffirms that you need to exercise reasonable skill and care. And you really need to look at the motivation for advertising a property is coming soon. Is it to allow the seller time to prep the property for sale, but to generate interest, or are you looking to double end your commission? And I will say that on the double ending the commission side, if you've had a conversation with your seller and you've basically told them that, you know, if I bring in a buyer, we're going to have a variable commission, which means that you save some money. That is also something that I don't think necessarily violates the license law, because you've had the discussion, they've made an informed decision. The important thing is that you've had the discussion with your seller and they are making an informed decision. If you're hiding from the seller that your goal is to bring in somebody and you're going to get a 6 or 7% commission, then chances are they're probably going to file a complaint with us, and we may find you in violation of the Brokerage Relationship Act. So just bear that in mind. The position statement's up on the website. And I really don't think it's a big concern. I do know that as of this morning, Zillow has put out that they are going to have coming soon advertising that will make your advertisements go on steroids. I don't know if that's going to result in compliance issues on steroids for us, but to date we haven't seen it. By no way are we close to being final on this. Is really revamping Commission Rule E8, which deals with advertising. And when we looked at changing E8, it became apparent that C19 and E8 probably need to be merged. C19 is the rule about names. I can tell you a lot of what we see, especially when the market is slow, is you guys start reporting each other. And it's either for advertising violations. Winter is a lovely time. Those are they either look like ransom notes because you like stuck the advertisement on the paper, and we get like the cutout letters letting us know that this is not compliant, or we get the bar napkins saying this broker's not advertising right. So we get either the advertisements where you haven't included the brokerage information, or we get made aware that you're using a name that you shouldn't be, or we discover that during the complaint process that, you know, I'm going by Marcia, but my name is, I don't know, Elizabeth Waters. So typically with the names, if common sense rules, if you're going by Shelley and your name is Michelle, we really shouldn't have an issue. But I can tell you that when I was an investigator, one of the complaints that I had, and I usually don't use names, but I don't know how not to use this guy's name. So, oh, okay. Does it need to go up? So, when I was an investigator, I had a complaint against somebody named Soon Min, and he went by Chad. Okay, I don't know how to make that deduction, so that's an issue as far as the name rules are concerned. So we're looking at merging C19 and E8. One of the things with C19 that we're also looking at changing is allowing brokerages to use multiple logos or trademarks. You'd only still be able to use one trade name, but there is one brokerage out there that is currently using multiple logos. And as long as the consumer can figure out who the brokerage is, we really shouldn't have an issue. But what you'll notice with the revamped E8, what we did was we took a rough draft to the commission last week at their meeting to see if we were on the right path. Sometimes they give us projects to work on a time and think that it's final, and then they kick it back and we have to redo it. So We presented them with a draft of this to see if we're going in the right direction. The current draft basically has a definition section, which at some point we may actually take the definitions out and put them somewhere else so that we've got kind of all-encompassing definitions. We do that with the Board of Real Estate Appraisers and the Board of Mortgage Loan Originators. When you work through the broker rules, broker becomes synonymous for a real estate broker and a brokerage, and it becomes kind of confusing when you're dealing with both types of licenses. So currently it's got a definition section, it's got a section that covers names. We will be addressing teams in this rule as well, instead of just doing it either through a position statement or a newsletter article. So teams will be in there. And it just reiterates that you can't use realty, real estate, realtors, company, etc. in your team name. Your team cannot appear to be a separate brokerage from the one that you're employed with. We're addressing internet, but we're not micromanaging internet. So with internet, what we're doing is it's proposing that the broker would be responsible for ensuring that the information is accurate and complies with copyright laws. By no means is the commission going down the road of enforcing copyright laws, though. So if for some reason you were deemed to be out of compliance with a copyright law, the commission could say, well, you're in violation of E8. It's also proposing that when you own or control your website content, expired listings would need to be removed within 3 business days. And also that when a third-party website provider is in the picture, the broker needs to provide a written request to have the expired listing removed within 3 days. So you just need to submit the request. However long it takes them is another story. So if we got a complaint that your expired listing is still up on Zillow for 2 months, but we see that you submitted, and I don't know that anybody runs their listings directly through Zillow, but if we got notification from you that no, I submitted a request with IDX and within 3 days to remove it, you should be fine. So that's the internet usage. We're also looking at kind of banner advertisements and social media, the one-click away concept where you've got limited space and you're not able to do the full brokerage disclosure. If you click on the link, it takes you to a website that then complies and has the full brokerage disclosure. One of the things that also is being contemplated is whether you need to put something more than just the brokerage name to identify where you're from, because with the internet, if it's just Marcia Waters, ABC Realty, they are not going to know that Marcia Waters is based out of California versus Colorado. So that is another thing that we're kind of contemplating. Now, something that is new that is being proposed with this rule is that it would prohibit brokers from using a professional designation in advertising unless the broker is in good standing and the designation is easily verifiable by the public and the commission. So if I'm claiming to be a realtor, they need to be able to go on and see that, yes, indeed, I am a realtor. We have several people that advertise that they're a realtor and they're not. And in the past, we've said, well, that's really trademark infringement. You need to go file a complaint with the Realtor Association. But we are looking at, essentially, it could come down to being a misrepresentation. So we're looking at kind of dealing with that. And it's also with the awards. If you're claiming to be the real estate broker of 2014, I'd like to know who issues that designation, and I'm sure the public would like to know as well. So it does not come from us. So that's advertising. We still have a lot to work out with this, but I will tell you that when we get kind of to a more polished draft and we've gotten more things addressed, we'll vet it to the community, meaning the licensees, before we actually go down the formal rulemaking process with Secretary of State, so that you guys have an opportunity to provide us with feedback and let us know that your proposed regulations are by no means, there's no way we're going to be able to comply with them. So keep an eye open for that. You'll get an email blast. And on that note, make sure that your email addresses are updated with us so that you get those email blasts, because that's primarily how we communicate with you. So that's advertising. The big thing that we're dealing with currently are forms. Now there's a 2-year moratorium on forms changes. We've passed 1 year. They did pass Senate Bill 1409, which requires language to be changed in the contract to buy and sell about mineral disclosures, and that will go into effect January 1st of 2016. So you're not going to see a change in the forms come 2015. But some of the issues that we're seeing don't have to do with the forms committee or the contracts themselves. It has to do with behaviors and how you guys are using the forms. So I will tell you on a regular basis, both through delegation of authority cases and the cases that go to the Real Estate Commission, we are seeing problematic uses of forms. We see brokers that don't use the commission-approved forms. I love it when I get an email first thing in the morning about, hey Marcia, I have a client that's contacted me that is in a lease purchase option, and they're not going to be able to exercise their option, but they would like to assign their option to somebody else. How do I manipulate the contract to buy and sell to accommodate that? And I say, you don't. You need to, your person needs to contact an attorney. We need to have an attorney involved. You should not be drafting anything. Put the pen down, please. So we see that. So we've seen people that have drafted their own contracts and their own addenda. We recently, after all the furor last year over letters of intent on the commercial side, lo and behold, here comes a complaint where we had a broker that was very crafty with her letter of intent about a nursing home sale. And it went very wrong, and she's now facing revocation. So we have seen issues where brokers have inserted personal provisions into the additional provisions of the contract to buy and sell. And one of which I've heard of is a broker was told by their legal counsel that it's okay for them to insert into the contract to buy and sell that the sale is predicated on the broker receiving a 3% commission. That is not acceptable under F2. So I would not encourage you to use that practice. The only time that you should be inserting language about your commission into additional provisions is basically when it's a term of negotiation between buyer and seller, and I'll give you that scenario here in a minute. And I can tell you if we get a complaint, we're going to be contacting buyer and seller to see if it was a point of negotiation. So make sure if this is a lie, and you're telling us a lie, that, oh yeah, it was a point of negotiation, you might want to make sure that everybody else is on the same page, because we do call and check. So we also we'll see documents from time to time that are, I will tell you that nobody in the real estate broker investigations section is an attorney. But we see these forms from time to time that even if they were drafted by an attorney would lead us to want to file a complaint with the Supreme Court because they are poorly drafted. My children would do a better job. So when we see those documents, we'll ask the broker, well, where did this come from? And they'll say, oh, an attorney drafted it. And we're like, really? So which one? And then they're like, oh, I don't remember the name. Okay, that's a problem because that typically tells us that that's probably not an attorney drafted form. We also see brokers just pull random forms off the internet. That's not appropriate. We've heard concerns about brokers that will see attorney drafted language that they like and they decide to use it as their own, and there's a whole issue with that as well. It's basically plagiarism. And then I will tell you that there was one form that was brought to my attention. I'll tell you about two. One that made me almost want to bang my head on my desk this year. It was a seller financing talking points addendum, and I'm not going to name names about who drafted it. But the whole reason that we took out the seller financing portion in the contract to buy and sell last year is because federal law has changed and state law has changed. And we didn't want to give you a loaded gun with which to shoot yourself in violating either one of those two. So I will tell you, state law says that if you're going to negotiate the terms of a residential mortgage loan or attempt to negotiate the terms of a residential mortgage loan or take an application for a residential mortgage loan, you have to be licensed as a mortgage loan originator. Federal law will provide, and Colorado law is similar but not identical, federal law gives sellers a 3-transaction exemption from licensure if it's done within 12 months. At the federal law, you have to make all of the mandatory disclosures that a loan originator would make. State law didn't go that far, and I can tell you that state law would basically be trumped by federal law because it's more consumer protective in that instance. But there are some other exemptions that are really ambiguous and difficult to decipher. And I would tell you at this point, if I was looking to do a seller finance transaction, I would just hire an attorney. Because the ramifications, if you don't make the required disclosure, are pretty ugly and would probably financially bankrupt you. So there was this talking points addendum that came out that was supposed to aid people in the discussion, and we said, oh no, the brokers should not be doing that because you're in violation of state law potentially and federal law potentially. And I will tell you, at state law, the Board of Mortgage Loan Originators views unlicensed practice a little different than the Real Estate Commission does. Typically with the Real Estate Commission, if you're out there practicing without a license, and most of the ones that we see practicing without a license are either doing property management or they are ambitious wannabe brokers that are waiting for their license to get issued. So our goal is to make you come into compliance with the law. So you either need to get licensed and stop the practice until you're licensed, or if you're not going to get licensed, you need to stop the practice altogether. So we'll issue an injunction if you're kind of an immediate threat. A lot of people are like, okay, I know my license is pending, I'm just waiting for my fingerprints or whatever the case may be, and they'll stop practicing. Board of Mortgage Loan Originators does not see things that way. They will issue a cease and desist order and fine you $1,000. And if you want to continue, then we seek an injunction, and it just kind of ramps up from there. So it's a different mentality. I just wouldn't go down that road. So there was the seller financing form, and we ended up issuing a bulletin jointly between the Real Estate Commission and the Board of Mortgage Loan Originators to say real estate brokers do not do this. The other form that we've seen is a hybrid between two commission-approved forms. And while it may save you time and frustration with dealing with one side of the transaction over the other, there are two commission-approved forms out there for you to use. And the policy is that if there's a commission-approved form for you to use and it's appropriate to the transaction, that is what you need to use. When I say need, it basically means you must use that. The only exception is the listing contract, and because the broker is a principal, then you can use an attorney-drafted listing contract for that. But you're going to be responsible for all of the mandatory disclosures that need to go into the listing contract. So with all of the issues that we've seen, what we're going to do is we're now working on clarifying the Commission's policy and the F rules, because apparently it's not as clear as it needs to be. It's not changing things unless you're doing the wrong things in the first place. But there are a few changes that will occur to F7, and we haven't gone down filing them with the Secretary of State yet. We're still working on it. But one of the things that we're clarifying is that when there isn't a commission-approved form promulgated, the broker may complete a form drafted by the broker's attorney that is specific to the transaction and appropriate under the circumstance. Now, I'll tell you that with that language, we need to clarify appropriate to the transaction, because when you're dealing with property managers, they are not going to hire an attorney to draft a lease for every time they take on a new landlord. So we need to deal with that. But we also addressed in CP 27, which is the position statement about property management, that if you have a lease as a property manager that you use day in and day out, you need to tell the landlord, well, I have a lease, you can use it, or you can hire an attorney. They need to have an option. So if you're going to use a form that's drafted by the broker's attorney, the broker needs to make sure that they know how to use the form and that the form is used and completed appropriately. And I'll tell you, the one hybrid form that is out there being used, which is a termination notice and a release of earnest money, we're getting complaints, and we're getting complaints from consumers that the form wasn't used properly. Brokers are trying to strike language and they're not doing it correctly. And in one case that we had gotten a call from, we got a call from an angry seller, and the earnest money should have gone to the seller. And that form has pre-printed language where the earnest money is going to the buyer. So the broker didn't strike the language appropriately, tried to write it in. The title company gets it. They look at the pre-printed language. They follow the pre-printed language that says it goes to buyer. So the seller is now out the earnest money, and they are not happy. So you need to make sure that the forms that you're using, even the commission-approved forms, you know how to use them. So that's F7. That's kind of the changes that we're looking at with that. And we're looking at also modifying F3, which is the rule that applies to addenda, to make similar requirements about it's the broker's attorney that is responsible for drafting the clauses. I will tell you that on an attorney-drafted form at this point, because of the enforcement issues, one of the proposals is to require that the attorney's name goes on the form. And after last week's commission meeting, we're also discussing that if you're using a form that your attorney has drafted for you to use, because there's not a commission one, it needs to be in a different font. It cannot look identical to a commission-approved form, which is another issue out there. So that's F7 and F3. One of the other F rules that we're looking at changing, we need to bring F1 up to speed, but there's really nothing substantive. It's just we need to change it to coincide with changes that have occurred over the years of the contracts. But F2 is another one that we're looking at changing, and it's to deal with the whole change in kind of business model of the flat fee brokers versus the traditional percentage split brokers. So currently, the issue that we've been trying to deal with and telling people, well, if it's a point of negotiation between buyer and seller, then your commission can go into additional provisions. It would be to modify the language in F2B so that it indicates a broker may, at the direction of a principal party, include language regarding payment of the broker's or brokerage's commission if this is a term of negotiation between the principal parties of the contract to buy and sell. So this would help just kind of clarify when you can or cannot put personal provisions into the contract to buy and sell. Otherwise, you don't get to do that. That's not the appropriate place. If you want to change negotiations about what you're getting paid as far as a commission, that needs to occur in basically an amend and extend for the listing contract. So those are the proposed F rule changes. Now what came out of last week's meeting is 1261-803 says that brokers may complete standard forms, including those promulgated by the Real Estate Commission. Brokerage Relationship Act is under the purview of the Real Estate Commission, so they've got the authority to define what a standard form is. So they directed me last week to define a standard form, which I told them a long time ago that this is not going to be an easy definition, so I will be working on that here, I'm sure, over the next couple months so that they at least have a draft for their August meeting. But I will tell you some of the considerations that will go into the definition of a standard form is how we kind of parse out the need for a transaction-specific form. So like Mr. Lease purchase option that wants to assign something, I would not expect that there's a template form floating around out there. That would be a specific one, but I also wouldn't anticipate that that would be a form drafted by the brokerage's attorney. It would be by the lessee's attorney. But we need to make a distinction between transaction-specific versus when you have kind of a template form that is drafted by the brokerage's attorney that you're using day in and day out. So that would be probably your standard leases that you're using, addendums, disclosures. Mold disclosure is one that I've heard about yesterday. So those types of forms. One of the things that the commission also discussed was that there needs to be training mandates if you're going to be using those forms. And I would presume that it would be basically the attorney needs to be counseling the employing broker about how those forms are used, and then the employing broker is going to have to transmit that on to their brokers. So I do anticipate that the mandatory education is going to impact E30, E31, and E32, which are the rules about supervision. And then the definitions, and as we work through this, it's going to clarify that they've got to be formatted differently. But they also wanted to have basically a requirement that annually the employing broker or designee sits down with the attorney to see if those attorney drafted forms are timely and relevant still, and that if there's any modifications that need to be made, that they're made. So you guys get to have your own little forms committees that watch legislation like our forms committee does to make sure that your forms comply with state law the way that we do. So that's forms. And I will tell you, we've reached out to the real estate section of the bar just because this is a very touchy issue. This is Conway-Bogue, and we don't want to see the Conway-Bogue decision reversed and you not be able to complete forms. So we are reaching out to them to get their input because the climate is definitely very different compared to 1957 when that case was decided. There is no shortage of attorneys. I know because they apply for my investigator positions all the time. So you'll get more from us on that, and we will vet it with the industry just so that you guys are kind of on the same page and you have an idea of where we're going. And as usual, with any rule changes, if you have suggestions or concerns, send them to us so that they can be vetted. One of the other things that we're working on that has come out of the Commission's annual retreat back in December was they wanted to do a position statement to deal with commercial property management the way they did with CP27. And they wanted to actually include commercial into CP27, but we have enough issues with residential property management that I think if you throw commercial into the mix, into the same position statement, it's just going to further confuse people. So I am working on putting together an industry group of experts that operate in the commercial area. If any of you fit that description, let me know if you'd like to participate in this working group so that we can put together a position statement that addresses commercial property management issues. And I don't think that this is going to be a quick and easy project either, but I am just now starting to put together that group. The other issue that came about in December was short-term rentals. There have been bait and switch activities primarily in the resort areas where you have somebody that wants to spend a week in Vail. They're in New Jersey, they send $10,000 deposit for this nice condo that they're supposed to be staying in Vail, and then they arrive in Vail and they've got a janitor's closet and their money is gone. So short-term rentals, historically we've had the position that if it's 30 days or less, you're dealing with a license to use. It doesn't require a real estate broker's license. However, if you're a broker doing them, you're held to a higher standard by virtue of having that license. The commission is considering repealing that position statement and asserting jurisdiction over short-term rentals. I don't necessarily know that they have the authority to go down that road, and that is something that I've asked the AG to look into. But the AG doesn't get a look into it until July when the new fiscal year happens, because they blew through their budget this year. So they get to look into that come July. I've reached out to the Hotel and Lodging Association because that affects them as well. So we need to get their input, but that is something that we are working on. And I should have something for the commission, hopefully by the August meeting, and if not August, definitely by October. One of the rules that you will see come to rulemaking, it will be on August 5th, that's the E&O rule. It was brought to our attention that one of the E&O providers would pay out legal defense, expend all of basically your claims money on that, and then when they should have been paying a consumer, they would say, oh, the funds have been exhausted, so sad, too bad. That's not how E&O is supposed to operate. We like that you have representation. We love to deal with your attorneys. But if there's a claim, you need to be paying out to the consumer. So basically, we have included that the language is that expense costs are outside of policy limits so that consumers are appropriately protected. You can still have your defense, but that will go to rulemaking on August 5th, and if they adopt it, it will become effective on September 30th. So that is one change that you'll see. Rice and Williams do not do that. So if you have one of them as your carrier, you should be fine. There should be no changes. And then lastly, kind of as projects are concerned, I've asked for the AGs to do an opinion on the impacts of marijuana on real estate, particularly your profession. Because I'm a little concerned as soon as, well, after January came into effect, everybody's like, woohoo, marijuana's legal, we don't have to disclose it. And I don't have the same comfort level as the people that were making the statements did. So I have asked the AGs to look into the impacts as far as disclosure particularly is concerned for real estate brokers and appraisers. Marijuana is pretty much a no-brainer for the mortgage industry because they're dealing with the federal banking requirements. So I have been told that this is not an easy task that I've asked them to do. It's going to take them a while. I do know that they're working on it. One of the things that I've been notified, though, is that once the AG opinion comes about, we're going to have to take it to the respective boards and commissions because they're going to have to make a policy decision. So we'll take it to the Real Estate Commission. They can make their policy decision, and whatever they decide, we will email that out to you guys, and we'll put it in a newsletter article so that you're aware. I don't know how many of you are dealing with marijuana properties. One of my staff bought one that had a grow room. I don't know what he does in his off time, but it is a reality these days. So that's kind of the last project, big project that we're working on at the commission level. I will tell you that back in January, we revamped our auditing process so that all of our financial examiners are on the same page, and really to kind of fine-tune and make it efficient. So as a result of that, we have a 3-tiered audit system. One is basically kind of a survey. We'll send it out, you do an affirmation and a questionnaire, and it pretty much ends there. And I would anticipate that if you're a sales brokerage that does not deal with funds of others, that's probably going to be the boat that you'll land in. And then we've got the second tier is a desk audit. Those are typically the low-risk ones. We don't feel the need to pay you a one-on-one visit. And then the last one is the on-site audit, and those are the high risk, and they're also the most time-consuming. And just by virtue of what they do, property management is high risk. And I anticipate that once we kind of work through property management, the other high-risk area is going to be subdivisions. We do go out and do the on-site audit, and I will tell you that we see issues with 3-way reconciliation for the property managers. We have had several cases where it's blossomed into an investigation, and investigation usually doesn't mean we're being kinder or gentler at that point because we're looking at license law violations. And I will tell you, They usually kind of fall into two categories. We've got brokers that don't know how to do the reconciliation, they don't know how to use their software, and they're not good at math. So if you're not good at math, we'll help you become better at math or find somebody that is good at math, because we'll put you on a regular audit cycle and help bring you up to speed. Versus the other category, which are the ones that we don't want to license anymore because they're not bad at math, they're really good at stealing. They're just not good at covering it up. So we have some that try to cover it up and it doesn't work out well for them either. Those ones we're really not inclined to want to rehabilitate. They need to find another profession, preferably one where they don't have access to cash. But that's primarily what the commission deals with. I will say that we have seen a mathematical issue, somebody not good at math that had an $80,000 trust account deficiency, which back in the day, under a previous administration, we used to just look at the dollar amount that was missing and say, well, it's over $5,000, no license for you anymore. With the $80,000 one, they did not revoke her. They have put her kind of on the path to fix her trust account issues and bring her into compliance. So we do look at things a little differently. We have people that actually request voluntary audits, and if you want to do that, you can. I know that they've got a. We try to help. We would rather help, but we're not going to help you if you're committing crimes. And for the ones that are inclined to steal, I will tell you that we have really been working on kind of building the case on why we need a separate property management credential at this point. But if it looks like you're violating the criminal statutes, we are required by statute, and we would do this anyhow because we like to share the love. We report you to the criminal law enforcement agency that has jurisdiction over you, and they get to deal with you. But I will tell you, with some of the cases that we've seen, criminal law enforcement just doesn't want to go down that road because they can't make heads or tails out of what you all do. So that's the real estate broker program. I will tell you, as far as common complaints that we continue to see is just failure to disclose material facts. These are kind of old hat. Criminal convictions. I will tell you that we probably know almost as soon as you're being arrested that you have been arrested. And so we get the hit that, oh, Marcia's been arrested for bank robbery. And I have one person on staff that all he does is follow Marcia's criminal case through the justice system so that they know that once she's pled guilty or been convicted, it now is our issue. So, and you still have a requirement in the license law to notify us within 30 days if you've been convicted. I will say that because of the CBI database and having somebody on staff that tracks these, most of the times we're catching them, but every once in a while we don't get the hit and we're unaware of it and we'll find out another way. So just make sure that should you have a run-in with law enforcement and it results in a conviction or guilty plea of any of the crimes listed under 1216-113-1M, that you notify us. Uniform duties continues to be an issue. It's our position that there's a list of duties under single agent and under transaction broker. You have to do all of them. You don't get to pick and choose. You can do additional ones if you want. That needs to be in writing. But we continue to get complaints about the MLS entry only brokers, and that's just not acceptable. So if you're seeing them, report them to us and we will investigate them, and you can file anonymous complaints. We continue to see issues with brokerage relationships. This whole concept of transaction brokerage, which has been around for quite a while, eludes a lot of people. I would not suggest being a transaction broker for your child, your spouse, any of your relatives, or a longstanding business partner, because those usually do not work out well. I already went over contracts, but that is a leading complaint issue. And then property management, it's the trust accounts primarily that we are seeing issues with. So that's the real estate broker program. I will quickly go over community association manager licensing. That will go into effect. The law goes into effect January 1st of 2015, but licensure is mandatory July 1st of 2015. So when this bill originally went through the legislature last year, we were told, oh, it mirrors the Real Estate Broker Practice Act. And it's like, oh, okay. And we'd seen enough similarities. Well, I can tell you now that I've sat down with it, it's not identical. There are some strange little quirks in it. So if you're a community association management company, the CEO is going to have to be licensed. And any executive of the business entity who has direct supervision or oversight of an individual who performs community association manager services is going to have to be licensed. Community association management is defined as, and these are really broad, receiving, depositing, controlling, or dispersing funds of the common interest community, preparing budgets, or preparing other financial documents. That's bullet number 1. Bullet number 2 is assisting in the creation and implementation of a reserve program for the replacement of capital assets. Number 3 is assisting in the provision of notice or conduct of meetings of board members or unit owners. 4 is contracting for, coordinating maintenance of property and facilities of the CIC. 5 is conducting property inspections, administering applications for architectural review, and keeping records of violations of the governing documents of the CIC. And lastly, number 6, performing other services related to the day-to-day operation of the common interest community. So to further confuse matters, there's a part that says you're exempt if you only, and you have to do any of those for compensation, typically more than one of those for compensation. Now, there's an exemption part that says a CAM, that's what we're calling them to shorten it, does not include a person who performs not more than one of the practices listed under the services that I just read, or any clerical, ministerial, accounting, or maintenance function not requiring substantially specialized knowledge, judgment, or managerial skill under the direct supervision and control of a licensed CAM or a contractor employed by a CAM or the CIC's executive board. So is the exemption clear to everybody? It's not clear to me, because accounting is in 2 places. It's in exemptions and also required duties. The whole maintenance thing is under both. So as we are working on rules for this and dealing with kind of the licensing criteria, if you have any feedback for us about kind of how this industry operates, and it touches more kind of entities than I would have ever anticipated, because I spoke last week at the Hotel and Lodging Association, and this is now an issue for them as well. Please send us your comments, because I don't think it's really clear who has to be licensed and who doesn't, other than the CEO. And I will tell you that when this bill was running through the legislature last year, one of the things that I typically look at, based on my background, is how do you circumvent the license law? How do you avoid getting licensed? And I was like, well, you do one of those. Well, if you're a company and you decide that Steve's going to do bullet number 1, Damien's going to do bullet number 2, I'm going to do 3, Ken's going to do 4, she's going to do 5, and she's going to do 6, well, the person that supervises them, they may not have to be licensed, but I'm going to have to be licensed as their supervisor. So this is going to be interesting. The other thing that is unique is that the entity can't get licensed until the designated manager and everybody that needs to be licensed has passed their exams. We don't do that with the real estate brokerages. And I will tell you, you do have, so brokers are not grandfathered in. You're going to have to get the separate license type. And you're probably going to have to get separate education. We are currently working on our own designation, because the ones identified in the Practice Act are the PCAM, the CMCA, and the AMS, which are offered kind of through one trade organization. Philosophically, that kind of goes against how we view things as a regulator. You don't have to become a member of a trade organization in order to get a professional license. So we're developing our own education so that you have that separate path. But there are other trade groups like IREM, as an example, that have submitted their education. We're looking to see kind of what is consistent and maybe what is missing, and for what's missing will help, hopefully, like a portion of the Colorado state law you might have to take, or will help kind of add on to their existing education so that those different designations can come into play as well. You will have to go through fingerprinting, and we can't use the fingerprints that we use for the real estate brokers because it's a separate statute and there's going to be separate requirements. And I'm sure you guys love to be fingerprinted at this point, because I know you threatened to cut your fingertips off when it came back unrecognizable the second time through. So that's going to be a joy. You're going to have insurance, but we're trying to define the insurance requirements based on how the entities are set up, because just one requirement for all would not fit. And I will tell you, prior to having the HOA Information and Resource Center in our office, and now this, I never thought I would be in a position to actually be empathetic for HOAs. As an investigator, we used to get the calls about my HOA is a Nazi faction and yada, yada, yada. And we're like, well, yeah, it sounds like it. That's why we don't live in one. So the HOA officer today walks into my office and he's like, it's Crazy People Day, Marcia. And I'm like, it's Crazy People Day every day for you, Gary. Unlike the other programs. So he got this strange package that was wrapped in like a kind of brown paper bag material, and he was really happy that we have somebody at the division that opens the mail for you, because he wouldn't have opened it. And somebody is so angry at their HOA that they actually published their complaint into a bound book. And he sent it not only to us, but also to them. He basically said on the back of the book that they did not have the spine to pursue any litigation against him for slander because they know he's right. And that it's just a criminal extortion agency. So I am really looking forward to the CAM licensing to go into effect. I may be looking for a broker before then to sell my house. I'm going to be buying a Winnebago, and regularly I contemplate whether I'm going to start carrying a concealed weapon or just carry open. I will tell you that unlike the rulemaking hearings for the Real Estate Commission, we have already anticipated, and I'm being serious here, rulemaking hearings we're going to be working with the AG's office to hold them over on their premises so that you actually have to go through security, and we will have a police officer present because those are heated. We already have the draft rules up on the website if you want to look at them. Some of the feedback, and I'm going to work through the feedback June and July, there are people out there that don't want other people to have any rights whatsoever. So that is kind of the concern that we have, because they seem to kind of ratchet the aggression up. And I'm sure I will be extremely popular because I get to be the designated decision maker on this one. So people are going to be unhappy left and right because I don't execute their association manager. I have told staff that you will know if you're on my list by the fact that I have designated decision-making authority on you for that program for a given week. So I have got 2 minutes left if anybody has a question. Gary?
So relative to marijuana, there's a very large association community here in Denver whose board of directors 2 weeks ago approved marijuana growing in the units, and they approved it in 2 formats. One format, if you have, and I may use wrong words, if you have a medical license, you can now have 12 plants. If you don't have a medical license, you can only have 5, those types of things. What's the impact on us as realtors who are actually working in that environment, and a lot of the current owners who, once they realized what the board did, they're now wanting to sell and get out of it?
So that is what I've asked the AG to look into, so that it's clear what you need to be worried about disclosing and how to manage that type of situation.
So, I mean, to give you just quickly one other comments, or 2 other comments in there. So this is a 50-year-old property. Half of the buildings are aluminum wiring. And each unit has a 50-amp power. And oh, by the way.
So you're going to sit in the dark and sweat because of your neighbor's marijuana grow operation.
Oh, yeah. So do you think that's going to come down soon from the AG or something?
So I did not give the AG the limitation on the marijuana opinion like I did on rental properties, short-term rentals. So they are working on it, and I can see from their billing that they've been working on it. I just need to see where they're at with it. But the sooner the better would be nice, because the appraisers are asking, well, when I go appraise and they've got a grow operation, shouldn't I be including that in my report? You know, what's the highest and best use now? Now that they've altered the property. So I will go back to the office and bug them about it. Yes?
I was going to ask a different question, but highest and best use, you can't consider that because they're legal to sell it. You can grow it, you can't sell it.
Well,
You can't sell it. Legally.
but if you've got a medical condition that it's financially better for you to grow yourself, who knows? But
here's my question. I've noticed through Craigslist and other things that there are people brokering marijuana businesses. And these people are not licensed real estate brokers. And I asked one of them, how can you get a license? And he said, said to me, well, because it's commercial property, not residential.
So there's no distinction in the license law between commercial, agricultural, but call it what you'd like. So if you're seeing that, file a complaint with us.
But it's practicing real estate without a license.
Yeah,
And there are many people who've been doing it for years.
that's okay. That's why we're here.
Catch those
You
first.
say you're taking
Yeah.
out these complaints?
We do. Just make sure that, so with an anonymous complaint, because we don't typically have the luxury of being able to go back to you and get more information, try to make the complaint as comprehensive as possible. And if you have evidence of it, send that in as well.
Okay, Marcia. I want to let everybody know we're going to have 15 minutes at the end
Okay.
for open questions, so let's just keep on track with the speakers.
Okay.
And then you'll be the first one to get questions. Okay, thank you very much.
Thank you.